D'abord, je suis très heureux d'être ici et de voir de vieux amis, de vieux collaborateurs de longue date. Comme c'est un projet que j'ai entrepris en anglais, je vais faire ma présentation en anglais, le texte sera aussi en anglais. Éventuellement, comme je sais de le faire, je vais probablement me traduire ou me faire traduire, mais pour aujourd'hui, ce sera en anglais. I would like to, since we're talking about federalism, first of all, I want to disclose that I will not be as poetic as my friend Jacques, and that my paper will be considerably more dry, actually, and arid. I would like to propose a kind of thought experiment, which draws on comparative law. And the title of my presentation, or the revamped title of my presentation, is the reconfiguration of the fiduciary duty and the potential relevance of federal loyalty, an interesting case of intellectual parallelism. In a case which is the Waikum case, the Supreme Court of Canada expressly associated duty of loyalty to the fiduciary obligation owed by the Crown to Aboriginal people. This was not a surprise in light of the previous case law and scholarly writings on that obligation. An oversimplifying, but nonetheless relatively accurate, I think, summary of the content given to the fiduciary duty by courts of law would reveal that failure by the Crown to consult Aboriginal peoples to whom the duty is owed prior to making a decision susceptible of affecting their interest, or if a change of circumstances, a risk affecting the perspective of the Aboriginal people concerned on the matter at hand, may constitute a breach of the said obligation, and so on and so forth. In a way, the fiduciary duty seeks, among other things, to ensure that Aboriginal peoples are not taken by surprise when a decision is made about their interest. It is central to the Canadian positive law as it applies to Aboriginal peoples. Now, and it's unlikely to change absent a kind of radical reconfiguration of the relationship between Aboriginal peoples and non-Aboriginal governments. This paper, however, seeks to, as I mentioned, propose a kind of thought experiment, which has both a theoretical and normative dimension. And the thought experiment in which I would like to engage is to examine whether federal loyalty could serve as a new paradigm for interpreting, in maybe a less paternalistic, a less narrow manner, the Crown's fiduciary obligation towards the Aboriginal people of Canada, should this relationship between Aboriginal people and non-Aboriginal government be reconfigured on the basis of some kind of federalism or quasi-federalism. And I mentioned at the outset the Waikum case, and in which the Supreme Court somehow identified as the core normative dimension of the obligation the notion of loyalty. Loyalty, I quote, loyalty, good faith in the discharge of the mandate, full disclosure appropriate to the subject matter, and acting with a view to the best interest of the beneficiaries. So loyalty is understood as forming part of the obligation's core. Now, the concept of federal loyalty hasn't been talked about that much in Canadian law. It is a concept that has been theorized in German constitutional law, in Belgian constitutional law, that has been appropriated to some extent in South Africa. And I'd like to see to what extent it can inform our understanding of a revamped fiduciary duty. So it's really a thought experiment with the limits of that kind of exercise. Now, let me briefly talk about the early life of federal loyalty in the concept, as the concept was developed in German constitutional law. And I will mostly speak about Germany here because that's where it was theorized, it's been appropriated, and you can find hints of weak versions of loyalty in federations that are very different from Germany. For example, even in Canada, when you're talking about committee, it could be characterized as a weak version of loyalty, very weak actually, when you compare it to what the Germans came up with. But still, it's interesting, I think, to look at what Germans came up with when theorizing and actually giving tangible legal meaning to the notion of loyalty. So the origin of the concept can be traced back to the emergence of another concept which designates in German the duty of reciprocal loyalty, which is Bundestreue. It dates back from the Bismarck era in the 19th century when Germany was actually coming together as a state. And then basically, according to Bismarck then, the Bund, the federation, was the result of an alliance unlimited in time, and Bundestreue was a means to promote its unity. In that model, obviously, unity was strongly emphasized, but also the contractarian roots of federalism were also emphasized, and the idea of consent. Around World War I, a German legal scholar, Rudolf Schmed, worked on the concept of Bundestreue, or federal loyalty, and tried to give it a more tangible legal meaning, because until then it had remained in the political realm for all sorts of reasons, because there was a will to get together and to create a strong German state. The Bismarckian state was rather authoritarian, and there was a commonality of views about what Germany could become. So there was no need to judicialize or to give some tangible legal meaning to the principle. So Schmed, more or less in the early days of the Weimar Republic, worked on this notion. The problems that he faced was that the concept of law in Germany then was very formalistic. Civilians among you may have heard of the École de l'exégèse. There was a similar school, a Begriff Jurisprudence in Germany, and the approach to the law was extremely formalistic. So talking about broad underlying principle was something that was seen as non-legal, purely political, irrelevant, and even dangerous. It's still seen like that in some circles, though. So Schmed's efforts were not brought to fruition immediately. It's really after World War II, with the enactment of the Basic Law, that everything started to change. Obviously, and quite understandably, given Germany's then recent past, where in 1951 the Constitutional Court was just created, 1949 is the enactment of the Basic Law, the Constitutional Court rejected that very formalistic approach to legal and constitutional interpretation, which had somehow facilitated the advent of the Nazi state. So it opined that a purely formalistic approach to constitutional adjudication could lead, under the guise of neutrality, to the demise of the new constitutional order, and once again to the triumph of the rule of man over the rule of law. So the German Constitutional Court had its kind of Marbury versus of Madison moment in the Southwest case, when in 1951 it decided, it said that there are constitutional principles that are so fundamental and so much an expression of a law that has precedence over the Constitution, that they also bind the framers of the Constitution, and other constitutional provisions that do not rank so high may be null and void because they contravene these principles. I'm still quoting, from this rule of interpretation it follows that any constitutional provision must be interpreted in such a way that it is compatible with those elementary principles and with the basic decisions of the framer of the Constitution. There is thus a kind of higher law made of implicit principle that transcends written law and binds both constitutional makers, legislators, and the judiciary as well. Democracy and federalism are among these principles. So the judicial discourse of Bundestreue, of federal loyalty in German constitutional law, stems from this logic, which reflects the centrality of federalism as one of the pillars of German constitution. And Bundestreue, federal loyalty, was used as a regulatory principle of German federalism, a principle that is actualized in concrete cases and that seeks to maintain